Okay, good evening. Good evening. Name is Kwame Gordon, and I'm a partner at Samuda and Johnson Attorneys at Law. He's excused the dress. I'm actually performing two duties today. And basically, I'd just like to share with you a little bit about the implications for employers in the light of the COVID-19, commonly called the coronavirus. And just to give you a brief run through of the laws that are available to employers to help them manage through this rough period and this very unique period. Now, there are laws which currently apply during this period which afford an employer the opportunity to either lay off workers, terminate workers for reason of redundancy, if it is that the employer finds that his back is against the wall, then he can probably consider initiating proceedings under the Insolvency Act to give his business some level of protection. Or in some very rare cases, treat a contract of employment as being frustrated by an act of God. Now, the one that is more common is the one that is called the laying off of workers, which is done pursuant to the Employment Termination and Redundancy Payments Act. And under that act, the employer is empowered to lay off his employees, such as in a situation as COVID, where there is a decrease in demand for services. The employer can lay off the employee, and the employee is entitled, if his layoff exceeds 120 days, to issue a notice to the employer asking that his contract of employment be terminated for reason of redundancy. Now, that only applies where the layoff of the employee is done without pay. Now, if the employee doesn't trigger the mechanism after 120 days, then theoretically the layoff can last indefinitely. But once the layoff exceeds 120 days, the employee is entitled to trigger the mechanism that says, I wish to be treated as an employee who is terminated for reason of redundancy. Now, termination for redundancy is straight off just saying, look, either the demand for the business has fallen significantly and I no longer need the number of workers that I previously used or previously had in my employment, and I wish to trim the fat, so to speak, and make persons redundant, or make the positions of those persons redundant, or a situation where the business closes and you wish to terminate your employment contracts for reason of redundancy. That is one of those methods which allows you to get a clean break of the employment contract. Unlike a layoff period, the person still remains in your employment during the period of layoff. With a termination for reason of redundancy, it's a termination of the employment contract. Now, the insolvency laws, as I said earlier, offer some measure of protection to individuals who wish to be protected during a financially stressful time. And basically, it's well suited for businesses that have suffered a severe decline, but they don't wish to close, but they may not be in a position to meet their obligations, their financial obligations. So that methodology or that option is also available. As I also said, there's frustration of contracts, but that one is very technical, and it does not necessarily follow that because a contract is experiencing some measure of hardship or inconvenience, that it is frustrating. But there are circumstances where a contract could be frustrated, and it's always good to get the opinion of an attorney at law before you proceed to terminate a contract or to claim that a contract has been frustrated. Now, most persons would have noticed that their government has been utilizing the machinery available under the Disaster Risk Management Act, and they have in fact implemented enforcement measures. So 3 orders have been, what you would say, passed by the Prime Minister, who is the Prime Minister in charge, who is the Minister in charge, and the latest one would have been the one that was passed in, let me just confirm the day. Yes, the last one would have been March 24th. No, I'm sorry, that's not it. March 31st, 2020. That one is actually an amendment of the previous order, which was passed March 24th, 2020. The first one has already been revoked. That's the one that would have been passed, I believe, March 16th, if my memory serves me correctly. That one has already been revoked. And the ones that are really in effect now are the ones that were passed on March 24th and the amended version of that one, which was the one passed on March 31st. For employers, the important thing to note is that the theme that is running through these orders is that employers should take such reasonable steps to prevent the transmission of this virus at the workplace. So what it does is that it limits the opportunity for working in the workspace if it is that the person can work outside of the workspace. Now, there are some entities that are exempted, mostly government entities, the security forces, and so on, the judiciary to some extent, and the House of Parliament are also exempted. Now, the amended version of the order, which was the one that was passed on the 31st, is the one that now incorporates the requirement for a curfew to be implemented. And the curfew is in effect from April 1st to April 8th of this year, obviously. And what it says is that commencing at 8 p.m. on April 1st, 2020, and ending at 6 a.m. on April 8, 2020, the curfew will be in effect. So within a little less than 2 hours from now, the curfew will commence, and it will end at 6 a.m. and it will continue until until April 8th, 2020. So that is really the essential things. There were some adjustments in the last order of March 31st regarding opening of markets, for example. Markets shall now operate from the hours of 6 a.m. to 2 p.m. Sundays, Mondays, Tuesdays, and Wednesdays, and 6 a.m. to 6 p.m. Thursdays and Fridays. Now, obviously, the curfew provisions will have an effect on jobs that are beyond 8 p.m. in the evening. And as such, one, there are some exemptions. Usually, you'll find exemptions for these sort of curfew regulations. In this case, it's no different. There are exemptions in respect of usually persons in the security field, correctional officers, judiciary, BPO, the business processing outsourcing sector. They are exempted. Persons who provide private security, the printing services, JUTC, those are the service providers that you will find who are exempted from the curfew regulations. The fact of the matter is that during that period, private entities that don't fall in the exemption groups are not supposed to find themselves in a position or in a situation where they are in breach of the curfew. And essentially what that means is that you must remain indoors during the time of the curfew. And that's a curious way of how it is phrased, because indoors, it never said at home indoors, it just said indoors. So the long and short of it is that if your work has to go on in the nights, it means it will remain, you may have to remain wherever you're working from the commencement of the curfew to the end of the curfew. But so that's an overview, and I am available if you wish to ask any questions. All right. Now, a question that is usually asked is whether vacation can be used during the layoff period. And it's a good question. And I think it's important that we separate the two concepts. Vacation and layoff are two different concepts. Vacation, or what is usually called paid leave, refers specifically to leave which the person is entitled to take as a consequence of working a certain amount of consecutive days. And it is modeled off the holidays with pay order. And the minimum is that persons who have worked for a year continuously are entitled to 10 days or 2 weeks. Usually the persons just call it 2 weeks paid leave, which means they count the weekends. Layoff means that the person's work arrangement is being suspended and they are being placed on a layoff with or without pay. Now, it's important to bear in mind that those are two different concepts. The moment you put someone on paid leave, it presupposes that they're entitled to return to work at the end of leave. So if you were to have a layoff period and put the person on paid leave, you have theoretically broken the layoff period. So you have to separate the two concepts. If the person is being placed on paid leave, put them on paid leave. The person is being placed on layoff, put them on layoff. Try not to confuse those two. Someone is asking, will you be compensated from your time away from work? I assume during the layoff period. The law is silent as to whether the employer has an obligation to compensate persons for the period that they were laid off if those persons are returned to their jobs. And the fact that the law is silent means that there's no statutory obligation that is imposed on employers to do so. Employers can elect to do so, however, if they are in a position to do so. But as far as I can tell by my reading of the law, there is no legal obligation on an employer to compensate you for the period that you would have been laid off without pay. Or the duty of an employer. The duty of an employer under the orders that have been passed pursuant to the Disaster Risk Management Act are the main duty is to ensure that persons who can work at home do so. So the employer is required to make an assessment, and if he's satisfied that a person can work at home, then his duty is to ensure that that person works at home. And he cannot penalize that person in any way, shape, or form if they work at home. There's also an implied duty in the order, which is that employers are to take such reasonable steps to prevent the spread of the coronavirus at the workplace. And how the order words it is very interesting, because what it basically says is that persons who are required to perform their job at home, at the workplace, sorry, which is that persons who cannot, under any circumstances, work from home, those persons shall work from home, but they can be permitted to be excused if the employer is undertaking steps to prevent the spread of coronavirus at his workplace, then he can grant permission to that person to work from home or not to be at the office, because usually it's in relation to persons who are incapable of working from home. Now, the interesting thing about how the order is drafted is that once an employee is entitled to work from home and the employer fulfills his duty and allows that person to work from home, then the grant of permission to work from home shall under no circumstances count against the leave entitlement of that employee. Excusez-moi. Let me get my tissue. Yeah, so once a person has received permission to work from home, that they are then working from home, and for the purposes of the order, they are considered to be at work. So therefore, you would not treat them as persons who are on leave. I'm allergic to something. I'm not sure what it is. Okay, we have a question here. What if, since the work from home policy has taken effect, the employer is unable to get in contact with the employee? No accountability of whether the employee is actually working. How should that be treated in a government institution? Oh, that's a very loaded question. All right. When you say government employee or government institution, are you suggesting that this is an institution that has been exempted from the requirements of working from home? Let us, for the purposes of the discussion, assume that that is the case. So therefore, the person is under an obligation to report to work. If the person is under an obligation to report to work and the order does not apply to them, then they are required to be at work, and you would treat them any way you would, as you would treat an employee who has failed to attend work. Now, generally, when an employee has not attended work and you take reasonable steps to contact the employee, and when I say reasonable steps, you contact their next of kin if you have information for that person. You, of course, try to contact them directly by email, WhatsApp, whatever means of communication that is available to you. You should also try to see if you can go to the employee's place of residence and make inquiries. And some employers go as far as to make checks with the police station that they know is close to the employee, or even a hospital, just to ensure that they cover all the bases. Now, once you have done those and taken those reasonable steps, you can treat the employee as having abandoned their job. Okay, operating under Circular 4, Ministry of Finance. All right, so the person is an entity which is exempt. If you look at the provisions of Order Number 2, Yes, those persons do not fall under any requirement or anything that says that they should not be in attendance at work. This, of course, is a very unusual time, and employers have to exercise a level of discretion. So, even though the exemptions would exempt certain persons in the public service, the fact of the matter is that you have to be aware of, and as I'm sure we all are as employees, we have to be aware of what is happening. And if, for example, the person lives in an area where it's difficult to get transportation, that has to be taken into consideration. If the person is susceptible to um, being a receiver of the virus in question, then that's something that you have to take into consideration. But nonetheless, the general principle is that if an employee fails to attend work, the employer is under an obligation to take such reasonable steps to locate that employee. Once those reasonable steps have been taken, then depending on what terms of contract exist and what policies exist for employees, that person may have abandoned their job. Now, in respect of those business places that are still operating, and let me make it clear, the law has not said that businesses should stop operating. All it has done is that it has placed restrictions in place. It has provided for restrictions for the operation of businesses. So the main restriction that most persons would be familiar with is the limitation on the number of persons who can be in a public space at the same time, and that's 10. And in terms of distances, they are required to maintain a distance of 3 feet from each other. The curfew is meant to restrict business activities between the hours of 8 p.m. and 6 a.m. And of course, like I said earlier, there are several entities that are exempted from the curfew restrictions, and and so they can continue to operate during that time. Or what if an employee is suspected of having the coronavirus? Well, the order specifically deals with that. There is a duty to make a report to the Ministry of Health once there's a suspicion that a person has either contracted or has come in contact with someone with the coronavirus. And of course, my strong recommendation is once the person displays any flu-like symptoms, that it's best that they self-isolate. And even if you don't know whether you're unsure whether it's corona or something else, it's always best that they self-isolate so that at least time can be allowed to reveal what the condition truly is. But certainly at the minimum, once there is a suspicion that someone has contracted the virus or has been exposed, then there is a requirement to report it to the Ministry of Health. Of course, the requirement has shifted somewhat in terms of to reporting to the Ministry of Health. When the first order came out, it was more a requirement for the individual to go and self-isolate if they have entered the country within a certain time. But now, under the new order, every person who enters Jamaica after March 18, 2020 has an obligation to contact the Ministry of Health and Wellness. So if you have any employees who have entered the island after March 18, they must make contact with the Ministry of Health. And of course, they'll be required to provide certain information so that the ministry can do an assessment and to do their proper checks and background background checks to see whether this person is potentially a threat. And I don't mean in a threat in the sense of the person is deliberately trying to be a threat, but they may be carrying the virus and they are not even aware that they are. All right, so if there's a breach of the orders, what happens? Well, the person who breaches the order, which could entail either disobeying a directive from an authorized officer or the director general herself or himself, or assaulting or abusing an authorized person. So, for example, a person who is authorized under the act to say you shall either go inside your premises or leave these premises and go elsewhere, and you refuse to conform with that instruction or you become abusive and assault them, then upon conviction at a criminal court, you can be fined, I think it's $1 million. Yes, fined $1 million. And if there is um, to a fine not exceeding $1 million, or the judge has a discretion of imposing a prison sentence not exceeding 12 months. So the penalty is pretty harsh, but there is a discretion. The judge can charge up to $1 million and can impose a prison sentence up to 1 year. All right. Now, in terms of flexi work arrangements, how does that work? Well, that's an excellent question. They used to work perfectly until we had a curfew. They don't work that perfect, as perfect as they used to, but they are still workable. And the government has been encouraging persons to use the flexi work arrangements under the appropriate legislation. And basically what it does is that it rotates people throughout the office. And that's good, because what you will find is that if everyone is in the same space at the same time, it increases the risk of transmission. Whereas if you can have a rotating door, so to speak, so when persons are coming in, some are coming out, and vice versa, then that may lessen the potential spread or the threat of the potential spread. Someone, all right, someone is asking, is there a need for a doctor's certificate to be submitted to your place of work if the employee feels there's a need for self-isolation? That's a very good question. The fact of the matter is that a need for self-isolation could mean that you're not displaying any symptoms, but you may have a fear that you have been exposed to the virus. So a doctor's certificate may not help in all cases. It could help in some cases. If, for example, the person starts to display symptoms, then a doctor's certificate could assist with that. But if the person is asymptomatic, but they are concerned that they have been exposed to an individual with the virus, then I don't think they need a doctor's certificate, but certainly there has to be some level of monitoring, because you don't want persons to abuse the process by just simply saying, well, I was exposed to someone with the coronavirus, so I'm staying home and self-isolating. But the fact of the matter is that even if the person decides to or suggests that they should self-isolate, if the person can work from home, meaning they are asymptomatic for argument's sake, and the person can work from home, then the employer should seriously consider that sort of arrangement. I hope I've been answering your questions. If you feel that there's anything I've missed, feel free to ask the question in a different way or to seek further clarification. One of the things that employers will ask, I've found, is what sort of regime they would have to embark upon if they choose to go the route of terminating for reason of redundancy. And usually that's code for saying we don't want this crisis to go to waste. How can we trim the fat and get rid of persons who we have always wanted to get rid of? That's an interesting question, an interesting way of putting it. Now, there is no established regime in our laws that says how you are to decide who to make redundant, meaning how do you decide whether you make employee A versus employee B redundant. However, there's an understanding by virtue of our labor industrial relations code is written that the process is to be fair. So if it is that you are thinking of redundancy, perhaps what you could do is to engage in a process that is fair to the employees. Now, not because you have had the repercussions from COVID does it mean that you are under no obligation to go through the consultation and the communication process that is expressly outlined in the code. You are still required to do so, in my view. It may not be as stringent because we obviously have a weakening economic experience because of a pandemic. But the fact that that is obvious doesn't mean that you should not have your communication and consultation process, because the whole purpose of that process is to get the employee involved in the decision you're about to make and see whether the employee can make suggestions which will avoid making the decision of terminating for reason of redundancy. So I won't lie, yes, it is true that it can give you an opportunity to improve on your systems and to find um, kind of trim the fat and locate those persons who are interested in, or who you are interested in staying with you, and kind of transform your business into I guess, a far more well-oiled machine. What if a person is ill with the flu-like symptoms but not necessarily exposed? They have been to the doctor and been given medication and sent home. Should they report to work or stay home out of an abundance of caution? Well, I, I mean, I'm no doctor, but my strong recommendation is that they should stay home. I mean, if for one, the fact of the matter is that our members of staff may feel uncomfortable being around someone who has the flu at a time like this, and it may affect staff morale and productivity. And for two, the virus, as I understand it, not being a medical practitioner myself, but the virus, as I understand it, is that it takes some time to actually start to show the symptoms that are typical of it, of the coronavirus. So it may start off as a flu, and then it graduates into something else, and potentially the coronavirus. So it's best if they stay home. All right. So one is asking, with the order for government employees, can one stay home and not work because resources were not provided by the employer? Um, all right. Well, the order for government employees. All right. Well, the order doesn't say that the government should not continue to work. The general position is that if an employee can work from home, then an employer, if he's satisfied that that can be accomplished, has a duty to see to it, has a duty to ensure that the person works from home. Now, if the person cannot work from home, then the person is required to work at their workplace with the restrictions, which may or may not apply depending on whether you fall in the exemptions or not. And the restrictions I speak of is how many persons can be in one space and the distance between those persons. Now, if the person, for argument's sake, um, is sent home by the employer, then it means, and they can't work from home, then it means the employer has accepted that this person cannot work at home. However, for whatever reason, I'm not granting them permission to work from home. No, it could be a matter of resources. They may not be in a position to give you the resources to allow you to work from home. And if that's the case, then the employer has taken a decision which is entitled to take, which is that the employer, or the employee is allowed to go home, but they are not required to perform any work. But there has to be a clear indication of that. Because the fact of the matter is that once you're not on paid leave and you have not been laid off, an employer can still insist that you perform work even at home. And it may not be that you are performing everything that you would normally perform while you're at the office, but he can still ask that you perform some amount of work. And nothing is wrong with that. I sincerely hope I've answered that question. And all right, and a follow-up question is, what if there are no resources to work from home? For example, there's no internet. And like I said, it's always a question of whether the employer is satisfied the person can work from home. If the employer is satisfied that the person cannot work from home, he can insist that the person work from office. But If it is that he is in a space that is not exempted from the order, then he must apply those restrictions concerning the number of persons who can work in the space at any given time, the distance that must be maintained. So there are things that he is still required to do, but it is a decision for the employer whether the person can work from home or not. All right, now when it comes to working from home, all right, if the person doesn't, okay, fine. When it comes to working from home, the employer, as I said, has a duty once he's satisfied the person can work from home to see to ensure that the person does in fact work from home. Now, that obviously is a question that has to be decided depending on the circumstances of each individual case. No one can set any definitive standard. But one thing that case law has revealed is that employers, when they're exercising a level of discretion, and in this case, I would submit that they would be required to exercise a level of discretion, that they should do so rationally and not arbitrarily. So therefore, if an employee, for argument's sake, has already worked from home, so it has been shown in the past that the person can work from home, then it's very difficult for an employer to say, well, this person cannot work from home. So it's always going to be a question of whether the employer acted in a way that was rational. What are our options now to reduce staff and remain compliant? Well, the one way is to rotate staff, and there are several mechanisms you can employ to include the flexi work arrangements. Other mechanism, which and the flexi work arrangements mean some during the course of a day, you have staff, different groups of staff coming in at different times. So some may work a shift from 9 to 12, some may work a shift from 12 to 4, some may work 4 to 6. And there's also the rotation of staff. Some come in Mondays, Thursdays, and Fridays. Some may come in Tuesdays, Wednesdays, and Saturdays. So employers have to find creative ways of ensuring that they stay within the remit of the order, which is to limit the number of persons in the workplace at any given time. And the number is now down to 10. So that they don't step outside of the requirements of the law. And it's going to take a little bit of creativity, I'll admit. And it's not going to always work as perfectly as you want it to. But it's a paradigm shift, and it is a reality. It has now become our reality. I have to find a way around it. But very good question. All right, so let me repeat one thing I said earlier about the market hours. So the market hours from the effect of 2nd of April shall operate only during the hours from 6 a.m. to 2 p.m. on Sundays, Mondays, Tuesdays, and Wednesdays, and 6 a.m. to 6 p.m. on Thursdays, Fridays, and Saturdays, which are usually the busiest days. So it therefore has been granted a 12-hour period as opposed to the 6 a.m. to 2 p.m. period for Sundays, Mondays, Tuesdays, and Wednesdays. Now, in terms of persons who are of the age of 65 years or more, the order, number 2 order, this is the order before the amendment, specifically says that between the 25th of March to the 7th of April, persons employed to the government who have attained the age of 65 years or more um, shall be required to attend. Um, sorry, those persons shall be required to work from home, and there are exceptions, obviously. So there are several exceptions to that rule, and it includes members of parliament, it includes members in the security forces, and so on. But the general principle is that once an employee has attained the age of 65 years or more, then that person, you should take steps to ensure that that person works from home. And of course, if you have employees that can work from home, irrespective of their age, then it is you're under a duty. Once you are satisfied that they can work from home, you're under a duty to ensure that they do so. All right, so persons who are working from home are now asking about lunch allowance and payment for internet, etc. All right, now that's a very good question, and it's interesting that you raise it because of how the provision is worded in the order. It actually says that once a person works from home, then the employer is to ensure that no decision is made that is adverse to them performing at home. Now, that's very vague and wide language, but I suspect it's wide enough to contemplate a scenario where you are to ensure that whatever benefits the employee would have received while working at the office, assuming those benefits are not directly connected to the office, then that person should continue to receive them. So if the person used to receive a lunch allowance while they're working at the office, it is possible that you are under obligation to give them a lunch allowance while they work from home. But if they got a travel allowance and that was to transport them from home to the office, then obviously that transport allowance is something that you may look at as something you could reduce. Now, persons are asking about, well, what about internet? I know I'm using my internet to do the employer's work. Should I receive some measure of compensation? Well, I think that is something that you could discuss with the employee, and it's not an unreasonable position for an employee to take. However, I suspect that the employee's internet facility is the same internet facility he or she probably had before they started working at home. So they would have to show that they had to either upgrade the facility significantly, or there is greater traffic and therefore they have to pay a larger internet bill for them to justify the difference between what they would have normally paid and what they are now required to pay. Obviously, if the person has to put in internet to facilitate work from home, then that is something I think the employer should look at in terms of reimbursing the employee. Should those benefits include overtime? Wow, that's a very good question. Uh, well, I could ask this: how do you determine whether the employee is working overtime? That depends entirely on the system of accountability that you have while the employee is working at home. If your system of accountability is so precise that it can track when the person is working overtime and there's an agreement to pay the person overtime, then that agreement continues to operate. But if you are unable to account for the person's time to actually know for certain that they are working overtime, then it becomes a little bit more trickier. Now, that doesn't mean you shouldn't make attempts to account for the time. You should always try and make attempts to account for the time. But that is one of those scenarios which is not that clear cut, and it will depend, in my mind, it will significantly depend on whether you have a system that can accurately track the time spent by the employee doing your work while they are at home. You are very welcome. especially if they are contract workers. I'm not sure I follow that question, but let me see if I can address it generally. No, I'm assuming when you say contract workers, meaning fixed term contracts or independent contracts. You could clarify that for me, but let us deal with both scenarios. Let us say they are fixed term contract workers. Then you treat them as you would if they were still working at the office, once they can work from home. So therefore, once the contract comes to an end, then unless you decide to extend it, the contract comes to an end. Now, when it comes to independent contractors, no, I, I, that one is a little difficult to understand or to respond to without specifics, because independent contractors usually don't perform their work within the employer's workspace on a regular basis. They tend to have their own offices, or they tend to have very little, if any, contact with their employers. So take myself, for example. I'm an attorney. I'm an independent contractor in the true sense of the word. So I take my work to my office. I'm employed by my employer, who is my client, but I take my work to my office and I perform it there. And I probably never see the client in their office. And if I do, it's only to discuss the progress of the matter or to hopefully get more matters out of them. So it's a little tricky to answer the question with independent contractors without specifics. Talking about laying off, terminating workers. How do you lay off fixed term contract workers? Okay, well, that's a good question. All right, now, if the person is the subject of a fixed term contract, then you can lay them off for the remainder of their contract. If, however, there is a fixed term in the contract, the person may not be entitled to a redundancy pay for the simple reason that the term was expressly set. Now, let me be very careful about that, because a lot of persons have a series of fixed term contracts and they assume that the person is employed under the last fixed term contract or the current fixed term contract. That's not necessarily so. If you have a series of fixed term contracts, that person could potentially be a permanent employee, especially where the contracts roll into each other, or there's a very short break in between, or where the person is not required to reapply for the job. They don't serve a probationary period each time. The term is just rolled over. So there are authorities which suggest that in those circumstances the person is actually a permanent employee and not a employee under a fixed term contract. Now, what if the fixed term contractor perform work within the company's office space? Well, and that's a very interesting question. If the person is a fixed term contractor, but they perform work within the office space, then there's a possibility that the contract, if it is, for example, the office is closed, there's a possibility that the contract has been frustrated because the circumstances that led to the office being closed was not initiated by either party to the contract. For all intents and purposes, the coronavirus is an act of God. So that could potentially frustrate the contract, but it's very hard to answer that question without a little bit more specifics. But yes, I could see a scenario where a fixed term contractor is no longer required to work from office, and there are no obligations owed to that contract due to the fact that the contract came to an end as a result of an act of God. Let me say something very quickly about fixed term contracts. the law presumes that a fixed term contract is not used where the position which the contract is being used in respect of is a position that is not a permanent post on an employer's what you would call organizational chart. So you wouldn't necessarily find a fixed term contract for a permanent post. It can happen, but usually fixed term contracts are when there's a specific task to be done and you want it to be done within a certain time by someone who possesses a certain level of expertise. So, for example, there's a project being done by the employer. The project will last for 3 years, and you're looking for someone with managerial expertise or managerial skill sets to manage the project on your behalf. You'll give that person a fixed term contract. But you know that once the project is over, you'll never need this person again. You actually move on to other projects which have nothing to do with this person. Usually that is the scenario, the ideal scenario for a fixed term contract. You're not really supposed to use it for permanent positions or positions where the person will be employed for indefinite periods. So just a little advice there about fixed term contracts. Be very careful about them. Get the appropriate legal advice before utilizing them. All right, well, let me thank you all for connecting with us today. I hope I was able to answer your questions. Just to let you know that Make Your Mark Consultants will be conducting their next Leading from a Distance series on April 16th. So, hope to see you then. And if you wish to contact me, I can be contacted at Samuda and Johnson, Attorneys at Law. And you can Google us, and we're in the New Kingston district. And I do have time for one final question if there's any. If not, thank you very much for your attention and for allowing me to spend a little time with you. Thank you for tuning in, and I hope I was of some assistance. And please be safe during this time.